number 21, Protect the Adirondacks, Inc. versus New York State Department of Environmental Conservation. Counsel?
Good afternoon, Your Honors. Jennifer Clark, appearing on behalf of DEC and APA. I request to reserve 2 minutes of my time for rebuttal.
You may have 2 minutes, Counsel.
Thank you. This is a case about building trails in the forest preserve. The third department erred when it deemed those trails unconstitutional solely due to the amount of timber cut to build them. The proper test for determining constitutionality requires the consideration of context to decide whether the trails will impair the wild forest nature of the preserve.
Counsel?
Yes.
Hello. Is it a fact finding based on the expert testimony that we cannot revisit? As to whether or not timber at the time that the word was adopted would include these smaller trees?
No, Your Honor, that is not an affirmed finding of fact. That is a question of constitutional interpretation, the kind that this court routinely is responsible for undertaking, Your Honor. As we're talking about the meaning of the word timber in the constitutional provision here,
Counsel, I'm sorry.
Yes.
Let me follow up on that issue. I do not disagree. It's a question of constitutional interpretation. But if it is argued below as a question of what was the drafter's understanding at the time, and that turns on experts testifying as to the historical context, why aren't we then bound by whatever are the facts related to the historical context that would then inform our constitutional analysis?
So I agree with Your Honor that, of course, there was historical testimony that was provided at trial, and that was part of what Supreme Court considered in making a decision that then ultimately was also considered by the third department. But those were ultimately legal conclusions that were made by those courts based upon the facts that were put before them, one of those facts being historical context. This court is certainly free to come to and should come to a different legal conclusion based on those same historical facts. And what we know here from the evidence put forth is that there was a distinction in 1894 and again in 1815 at both the constitutional conventions between timber and trees, and that the delegates to the constitutional convention chose the word timber for a reason, that there was commercial logging that was occurring at the time.
Can I stop you for a second? Judge, thank you. The 1915 convention, that constitution was rejected by the voters, wasn't it?
Yes, Your Honor, it was rejected by the voters, it doesn't have...
That being the case, why would we use the 1915 arguments to interpret the 1894 delegate analysis of what the meaning of the word is?
Well, Your Honor, I think that what was discussed at the convention in 1915, as you mentioned, the proposal that was ultimately rejected by the voters was adopted by the delegates, and in having their discussion surrounding that, it sheds light on what they understood it to mean at the time and what they understood it to mean in 1894, which was much more recent then than it is now. So it provides additional historical context for us, and it provides additional intent information about what the delegates wanted at the time when they were enshrining this constitutional protection.
Much of the argument, once we move beyond whether trees equal timber or timber equals trees, which seems to me to be an esoteric argument that misses the underlying point, which was that the purpose of the constitutional amendment was to preserve as much as possible the forever wild nature of the Adirondacks Preserve. And so whether it's 6,100 trees that we're talking about that qualify for the timber are 25,000, we're still talking about a significant reduction in the overall number of trees in the Adirondacks. What I'm wondering is most of the argument that you make appears to be, it's a rational argument, and it's really what I would expect from DEC if DEC was told they did not have a rational basis to do what they're proposing to do. And you're saying, no, we do have this rational basis to go ahead and do these things. These are very familiar arguments. You know, we studied it, we counted up the number of trees, we thought the effect would be minimal, and so we thought it would be a good idea to go ahead. What I wonder, though, in the context of the Constitution, and what I see, particularly in the Adirondacks versus McDonald case, is that when they're talking about the bobsled run in 1930s being put into Lake Placid, and that was a violation of the Constitution, the court ruled then, and that's still good law today. And that analysis says to me that something may be rational, but it could still be unconstitutional. It's perfectly rational to put in an Olympic park to attract people. It has good economic benefits. It's certainly a legitimate form of recreation and something that the state could be proud of. But this state made a policy choice, and the policy choice that they made, and they've preserved for over 100 years, was to say that while that may be a perfectly rational choice, those economic benefits, whether it be commercial logging or snowmobiling, result in a destruction of this forest and a compromise of the ecological validity, actually the unique gift that we've been given from God to preserve this. And that's why they said in 1930, it's rational, but it's not constitutional. And I'm having a hard time seeing why this is any different, I guess is where I'm at.
Okay, so, Your Honor, I agree that McDonald is certainly still good law, but there is a gulf between the project that was proposed there and the project that's proposed here. And just to be clear, you know, the purpose of the constitutional provision was certainly to preserve the wild forest nature for future generations of New Yorkers. And part of that was to preserve it so that future generations of New Yorkers could enjoy access to the preserve. So it's not a question, you know, the state's not arguing that it's some kind of balancing test with different factors and that somehow you have to balance access against preservation. The idea is that you would preserve the wild forest nature, minimizing any impacts while making sure that the primary goal of the delegates to preserve it so that future generations of New Yorkers could enjoy and access it is accomplished. So in McDonald, this court took a contextual view. They looked at the fact that it would be not just not just the numbers of trees cut in McDonald, but how that cutting would take place. It was in a very concentrated area. It was the equivalent of a clear cut, basically in one concentrated area. It involved bringing in mechanical implements that one would not normally expect to find in the forest preserve to allow this bobsled run to go up and then have a return. It was an extremely wide area that they would be cutting from. Here we have trails, trails that do not disturb the forest canopy. We have an affirmed finding of fact that these trails are not visible from above. Let me stop
you for a second. I don't believe the record supports that. I think that the destruction of the overstory in the forest has been described as minimal. And this is a case of one man's ceiling is another man's floor. The wild preservation of the forest will not survive if the forest overstory is destroyed. And that would mean it's a death by 1,000 cuts is what DEC is presenting us with here. They're saying this is a scientific form of forestry that we can do and it will have a minimal impact. But 1,000 minimal impacts, and they will take place once we allow this to go forward. And if we should allow this to go forward, we would be saying, not that what you're doing is wrong, but we're saying that all these little things that you want to do will have no impact on the forest itself. And that simply is contrary to everything we see around us today. On a daily basis, the forests in North America are burning to the ground, and this proposal would affect the overstory that protects the only truly wild forest in the eastern United States.
Your Honor, with regards to just to come back quickly to the forest canopy, both experts agreed that they would be maintained intact throughout. These trails are 9 to 12 feet in width, and many other trails in the forest preserve also run approximately 8 feet, including for hiking, for cross-country, for horseback riding. So this is not a new kind of trail that doesn't otherwise exist in the forest preserve.
Counsel, let me
If you look
understand
at
under, counsel,
the
if I can-
record that-
counsel, I'm sorry. I can interrupt
Yes.
you, and I know your red light is on. If the Chief Judge will permit me this one question. If I'm understanding your interpretation of the Constitution, that would permit every seedling, every sapling that's below what the entity, the agency has decided is the threshold of what's timber, what's a tree, to be destroyed. And that would not be in violation of the Constitution. Why is that not a proper sort of end result of your analysis?
Certainly not, Your Honor. That is not at all the test that the state proposes, because the first sentence, the wild forest, the forever wild provision is divided up into two sentences. The first sentence requires that the lands shall be forever kept as wild forest lands. So every portion of the preserve, whether it be a seedling, a sapling, a huge tree, or a vegetation that is not a tree, is protected by that. So everything that is done must preserve the wild forest nature. And that is true regardless of how this court interprets the word timber in the second sentence, and whether they agree with the state's interpretation or not. It still remains true that the overarching goal of the provision, which is to preserve the wild forest nature, must be maintained.
Judge Wilson has a question for you.
Thank you, Chief. So, counsel, if you're viewing the first sentence as independent of the second, which I understand you to be saying, and correct me if I'm wrong, then why isn't it correct that the records of the convention, supplemented by the Attorney General opinions from the 25 years or so after that, demonstrate that the intent of the first sentence was essentially that the forest preserve be left as untouched by man, or as created by God? Those are sort of the words that are used to describe the intent at the convention and the interpretation of several Attorneys General from 1895 through 1915 or so. Why don't you lose under the first sentence if it's independent of the second?
So, Your Honor, just to clarify the position of the state, I think it's best understood that the second sentence is making explicit that which is already implicit within the first sentence, rather than that they necessarily operate independent of each other. Rather, it's that the second sentence is highlighting specific concerns that were animating the delegates at the time. It's more like a clarification or a specification of some of their particular concerns, rather than any argument that they're operating independently. Actually, we believe that they need to be read in light of each other rather than independently. If you look at the primary conversation among the delegates at the 1894 convention, they are discussing two animating concerns. Obviously, in the background concern is the commercial logging. So the goal is to stop that from happening. That is the historical context. And their goals for the future are to preserve the forest preserve as a great resort for the people, and to make sure that its value as a watershed is protected. And those goals help explain what would preserve the wild forest nature. Access to the preserve for New Yorkers of all abilities is perfectly in line with, and is in fact the animating purpose of, protecting the preserve for future generations.
Chief, can I ask a question?
Yes, Judge Garcia.
Counsel, why, if you look at the provision which has these sentences we've been talking about, there's another few pages of notwithstandings, you can do X. And I know some of those are roads, some of those are but some of them are ski trails. I mean, why doesn't that give the impression, at least, that this constitutional provision is so strict that to do these types of things, for example, to build a trail for motorized vehicles like snowmobiles, you need a constitutional amendment?
So, Your Honor, if you look, it's true, there's a long list of constitutional amendments. If you look at what they are things that look a lot more like the bobsled run in McDonald than the trails that we have here. Your Honor mentioned ski slopes. Those are, we're not talking about cross-country trails, cross-country skiing trails. Those are 150-foot, 200-foot wide downhill ski slopes that require bringing in mechanical implements to, something you need to get up and down the ski slope that one would not expect to find in the preserve. We're talking about highways that require, that do disrupt the forest canopy greatly and that require paving, something that also one would not expect to find in the forest preserve. Those are also, things that don't necessarily further the purpose of maintaining it so that it can be enjoyed by all New Yorkers. What you'll see is notably absent from the list of constitutional amendments is a trail of any kind. There are no trails on there because trails are in line with what this constitutional provision was put into the Constitution for in the first place, maintaining the wild forest nature of the preserve so that it could be enjoyed by future generations.
That might be a hiking trail, I think, but this is a trail for a mechanized vehicle. So you talk about putting a ski lift in, you're talking about mechanized traffic going through a road, which to me looks more like a road than even a ski slope. So, that looks more like some of these things that they've gotten amendments for.
Well, Your Honor, I want to interject there because plaintiff specifically did not pursue a challenge against snowmobile use. That is not part of this litigation. We are talking about the trails. These are multi-use, multi-season trails. They're primarily 9 feet in width, and as I mentioned, other trails in the preserve are
Can I stop you there 1 second? Ma'am, can I stop you 1 second? I understand that argument, and you're correct as far as the record goes. I think that's unquestioned. But the way I understood Judge Garcia's question is the primary use of this type of Class 2 trail is to allow snowmobiles to use it. And the use of snowmobiles, besides having an economic benefit for the surrounding community, does bring a mechanized road-like nature to the trails that are being designed. There's no other purpose for a 9-foot trail than to put in a snowmobile. It seems to me disingenuous to argue it as anything other than that. I mean, you're totally right. They dropped the idea. We're not saying that snowmobiles can be banned from the park. I think you're right about that. But what we are saying is that the design for these trails is primarily a design to allow access to snowmobiles. And my review of the record seems to show that all the Class 2 connector trails throughout the park are really designed for that particular purpose.
Your Honor, you're right that snowmobiles are one of the uses, pardon me, for these trails. Certainly that is true. And in order to protect those who are using the park, yes, there is a certain width requirement. That width requirement is not a large deviation from other trails in the park that accommodate all types of other uses like snowshoeing, cross-country ski trails, horseback riding trails, and that are about 8 feet in width, and hiking trails that range from 3 to 8 feet in width. And I would disagree with the idea that the construction techniques used here are somehow more akin to what you would use to build a road. In fact, we have affirmed finding of fact that's supported by the record evidence to the opposite, that these trails are actually more akin in their construction and their impact on the surrounding environment to hiking trails than they are to roads. And there was a 13-day trial at which plenty of evidence was put forth, and that was the conclusion by Supreme Court that was upheld by the third department. So the record does demonstrate that these are much more similar in construction and impact on surrounding environment to hiking trails.
And Chief, I have
Also,
one
what
more.
would some of the practical effects of the AD analysis be on DEC's policies and activities and projects?
Sure, Your Honor. So it is what has happened since the appellate division decision is that the state has ceased construction on trails of any kind. That includes planned trails, foot trails, relocating hiking trails, building new hiking trails. They have also not undertaken some projects, including building new water lines for safe drinking water access and other kinds of just general maintenance that need to be undertaken in order to maintain the trails that already exist. So certainly the impact of the appellate department's decision has been that it has had a wide impact on what the state has been able to do in the preserve. And along that same line, I just want to be clear when we're talking about, I believe the phrase before, death by 1,000 cuts. I want to make a couple points on that front. First, there's an upper limit that is in place to the amount of trails that are allowed in the preserve that are open to snowmobile use. There are limits in the preserve on the types of land classification that can be open to snowmobiles. They're only allowed in wild forest lands and not the other types of lands. And APA and DEC take seriously their responsibility to safeguard the preserve. That's in the state land master plan, which dictates that there be no material increase in existing trails accessible to snowmobiles. So what you'll see in this case is that because there were some additional trails that were built that were open to snowmobiles, miles of trails that had previously been open were closed to snowmobile use, that they moved trails that were in sensitive interior areas out to areas that are much closer to the roadway so that there's a net benefit to the forest preserve.
Counsel, Judge Stein here, if I could just follow up on the Chief Judge's question. So you talked about what DEC has not felt that they've been able to do, but what is the effect of that on the public use of the forest preserve?
Your Honor, so I think it's important to remember that that we're not just talking about. Of course, this case is about the trails at issue in this case, but DEC and APA, of course, take, as I said, very seriously their responsibility to be stewards of the preserve. So, as you know, with regards to overall the building and maintenance of trails that would provide access to the public, the appellate department's decision has caused them to cease building and relocating trails. It has caused them to need to pull back on some maintenance that they would otherwise be doing because the standard put forth by the appellate division is simply not workable and impracticable for them to do what they need to do in order to ensure access. And I'm not just talking about these trails. I'm just sort of speaking there more generally, as Your Honor asked, sort of about the overall impact.
Thank you,
Of course, all work on these trails
Judge, can I ask?
Fahey?
I'm sorry we're going over this, but what's your understanding of what the phrase "forever wild" means legally? And let me tell you, it's a hard question. I'm not, if you don't have the answer on the tip of your tongue, I understand. And I've struggled with it myself, but I think it's important for us to have a sense of what are we talking about here? What does forever wild actually mean? Is it a balancing of interests between what people could use the forest for and the nature of the forest itself? is a snowmobile encompassed in what the phrase forever wild means? Is a ski slope, are these things, or is just simply a constitutional barrier that can only be surmounted by the people of the state of New York voting, not this court or anyone else? What do you think it means?
Well, Your Honor, the words of that first sentence that you're referring to are that the forest preserve shall be forever kept as wild forest lands. And I think that, of course, exactly what that means is a question of interpretation. But the best guide that we have is what we know from the historical record. The delegates were convening to protect. And what we know is that there was extensive commercial logging taking place at the time. The delegates wanted to stop that, and their concern
Let me ask you this. Let me ask you this. Wouldn't you say that it was a radical move in 1894 to declare 25% of the state of New York off limits to all development?
Your Honor, I don't know if off limits to all I guess I don't know what all development means. I don't know that, as we know from McDonald, there is not an absolute interpretation of the destruction of timber clause. This court explained that to us in McDonald already, because an absolute interpreting that term absolutely would mean minimal or no access for New Yorkers. So, I'm not sure that one can read it as no development.
I do struggle too with what forever wild means, but I think in the struggle to deal with it, if we're going to change our thinking on it, then I guess the question for us really comes down to, how do we do that? Do we do that by a court case or a bureaucratic DEC ruling on what constituted, or like Judge Garcia said, do we have to vote on it, and do the people of the state have to vote on it to make that kind of change?
And Chief, if I might have one more, if you entertain it.
Judge Wilson?
So, Counsel, I wanted to ask you, in light of Judge Garcia's questions, my understanding is that the most recent amendment to the section of the Constitution was by referendum in 2017, which created a land bank. Are you familiar with that?
I'm familiar with that amendment. I don't know if I would know necessarily the historical background, but yes, I'm familiar with the amendment.
So my question really is the following. At least as I understand it, the idea was that there were small things that these local communities needed to do, including sometimes putting up a pole to carry a cable wire, or bracing an existing telephone pole, or small things like that, that were going to require a constitutional amendment each time to do that, because the brace or the pole might have to be on forest land. And the idea was to create a 250-acre bank of land that local communities going through a bunch of hoops could draw on, so long as they at least one-for-one substituted provided money that could be used to purchase other land to add to the forest preserve. And so if my understanding there is correct about how that's working, my question is, doesn't that then suggest that this constitutional provision is so dramatic, so forceful, that even the current understanding is that to brace an existing telephone pole, if the brace is going to be on the forest preserve, you have to amend the Constitution. And what the legislature, after what looks like many years of negotiating, finally came up with this land bank solution. So my question is, isn't your interpretation sort of inconsistent with what the legislature most recently thought and what the people most recently voted on?
So with the caveat that I don't know all of the background of that, but taking what Your Honor said, I would, what really is left out of that is the idea of the purpose of the provision in the first place, and the purpose of any kind of project that takes place thereon. We know that the purpose of the provision was to protect the preserve so that it could be enjoyed by future New Yorkers. What Your Honor is describing does not fit inside that. It's for municipal convenience, or for municipal telephone lines or whatever, and certainly that's important, but that has nothing to do with allowing New Yorkers to enjoy the wild forest lands. So I think that is the thing that's really missing there. And if one looks at what is missing from the amendments, they are trails that provide access to New Yorkers, which is really at the heart of the constitutional provision.
Thank you, counsel. Counsel?
Thank you.
May it please the court, John Caffrey for the plaintiff and cross appellant, Protect the Adirondacks. And I would like to reserve 1 minute for rebuttal on our cross appeal.
Sir, you don't get rebuttal time.
Okay, thank you. That's fine. Then I get more time now. If the court follows the precedent set by the Association versus McDonald case, then the defendant's appeal has to be denied and the plaintiff's cross appeal has to be granted. What they want you to do is overturn the precedent set by Association versus McDonald. We think that one of the primary issues to be decided here is whether the prohibition...
What do you think would have to be overturned? Over here. Sorry. Because my reading of McDonald is that, first of all, they said a reasonable interpretation in view of the purposes of the forest preserve. And I think as your adversary has described, what was at issue there is very, very different to what is at issue here. And in addition to that, as I read the papers in the McDonald case, it appears to me that they only were talking about trees of 3 inches DBH. So what is it about McDonald that you think that they're trying to overturn?
Well, first of all, I would disagree that what was proposed in McDonald is all that different from what's proposed here. The bobsleigh run was proposed to be 6 to 20
So does
feet
your
wide.
argument then depend upon that interpretation that there's very little difference between what was at issue there?
That's only
then?
part of it. What the McDonald case said at its heart was, yes, the forest preserve was to be preserved for the use of the people, but only if it doesn't result in the destruction of a material amount of trees. So that has to take primacy over the access issue.
But doesn't that have to be what is material and what is substantial? Doesn't that depend, if you have a forest preserve that is 10 acres, okay, and you want to remove 50% of the trees to put in a parking lot, okay, well, that might be substantial. Now, what if that same parking lot was a spot for 2 cars to allow hikers to go in to a forest preserve of thousands and thousands and thousands of acres, and I don't know what the total number of trees would be. Doesn't the context of what you're talking about, as well as the purpose, make a difference? Isn't that what McDonald said?
I don't believe so. In the McDonald case, if you read the statute or the session law which authorized the bobsled run and directed Commissioner McDonald of the Conservation Department to build it on the forest preserve, and the statute's quoted in the synopsis of the appellate division decision. That was the only place I could find it. It said the bobsled run was to be for the use and benefit of the people. It said it was to be destroy or cut no more trees than were needed for its width, and that care was to be taken not to damage the adjacent forest. So there, in effect, is what the state has said here is the context. We're being careful. We're minimizing the damage. Faced with a statute that said that, the McDonald court still said that was not permissible because it would destroy a material amount of trees, and also because, separately, the bobsled run was not consistent with the wild forest nature of the land.
Can I stop you 1 second? So are you saying to us that they used a 3-inch DBH standard in McDonald, right?
Not really, no. That
Well,
was the data.
let's just say that they did, all right?
say that they did.
All right, slow down. And they're using a 3-inch DBH standard here, right? And so therefore, if I understand your argument, you're saying it would be the same. And if it was wrong in McDonald's, it's wrong here, right? Is that what you're saying to us?
In effect, that, yes, if you cut that many trees, a substantial or material number of trees, it's wrong regardless of the purpose. And if it's deemed desirable by the people of the state, they can
Well,
go and
But
get an
can I,
amendment.
can I follow
to the
up on
Constitution.
that for a second? To go back, I think, to what both Judge Fahey, I guess, and particularly Judge Stein are saying, as I read McDonald, there is this overlay, and there's some almost conflicting language, but that, look, you have the statement that they adopted a measure forbidding the cutting of these trees to any substantial extent for any purpose, right? That's pretty broad language. But there does seem to be the suggestion in McDonald that the purpose has some effect on how you analyze substantial. So what would concern me would be, would you apply the same test to action taken to prevent damage to the forest, right? And I think it's mentioned somewhere in McDonald. Like, what if you're clearing trees to prevent a fire, right, or a fire hazard? Would you count trees in the same way, so to speak, that you count trees for a toboggan slide or for a hiking trail? So it seems there are three categories to me. Prevention-type maintenance on this end of the spectrum, then private type of use, quasi-private maybe, of the toboggan slide, and in the middle is this kind of let's enhance public use purpose. And so what I struggle with is there a different approach, or is a consistent approach, but that we apply differently because this is a different purpose here?
I don't think it's a different purpose. I think the approach is the same if you read that sentence.
But what about the fire hazard? Would you still just count
I
trees?
think we could have a long discussion here about let burn versus natural fire, such as we see in the West. And, you know, there's a long history of that that's really outside the record, or I believe outside the scope.
But do you think that's a discussion a court would really want to get into on a Forever Wild challenge when they come in and they say, look, we have to clear 2,000 trees out of this area because if we don't, there's the X damage to the forest, and then they litigate that for 10 years?
Well, I guess one could say that fire is a natural part of a forest ecosystem.
Well, but so then would the Constitution prevent you from fighting a fire in the forest that
No, it
was
would
threatening,
not.
adjacent
No,
homes?
and-
Well,
and-
but why not?
Is it because
If the burned-out forest is the natural condition, then why not?
because it's to some extent, it's not necessarily natural. And I really think that issue is not here before.
But you're
us.
saying it's the same test for every purpose, so how do we distinguish that if we wanted to?
In the case of a fire, if it was threatening catastrophic damage, you may
Or
have to
let's
look at it.
say there was a burn before and now it's getting close to a residences, and they want to clear out some of the smaller trees, and they want to, create some kind of a things to prevent that, in their view, from spreading into this residential area. They got to get a constitutional amendment to do that?
No, of course, there wouldn't be time. And there may be room in McDonald in that particular situation. On the other hand, I don't think it would.
Well, but
If we
Judge
get
Garcia's
back to
question is,
the
Judge
recreational
Garcia's question is
situation.
why there would be room in McDonald for that particular situation. Where in McDonald is that room?
It says all things that are necessary could be allowed, but it clearly, if you parse that sentence, it clearly says that when it comes to access for public use, that is only if the amount of tree destruction is not substantial or material.
So
In
if
that
I'm
case, we're
understanding
dealing
you,
with
is the
that.
point you're trying, if I'm understanding what you're saying, you seem to be drawing a distinction between actions that might at first blush appear or consistently be destruction of trees, but the point of that is to save life or property that's external to the preserve. And therefore, that might fit within McDonald's, what you're quoting now, this language about what is, all that is necessary?
Well, I think in McDonald, they're talking about protecting the preserve itself.
No, but that's why I'm asking you. I thought the question posed, I may have misunderstood it. I thought the question posed, what if, not the fire internally, that was one line of questioning, but what if the fire now jeopardizes life and property external to the preserve? Are you drawing a distinction between those two scenarios? I thought you were, but I may have misunderstood
I'm not
you.
sure McDonald answers that question, and I don't think this court has to.
Well, can I ask you this, in fairness to your opponent, what do you think forever wild means, and what do you think that phrase in the Constitution means?
I think the best definition is towards the end of the McDonald decision where it says to preserve it in the wild state now existing. I also think it's instructive to look at the essay by Robert Marshall that was cited in the Court of Appeals decision, where it basically says there's little or no sign of man other than trails or temporary shelters. And those are the types of things that I believe were intended by the Court of Appeals in McDonald to be.
So if I understand you correctly, you're saying basically that you view the forever wild provision is one where the human use of the forest is allowed, but it's limited to that which doesn't destroy its uniquely wild nature.
I believe that would be a good definition.
So let me ask you this, counsel. The state is saying, well, you know, because of where we are in this litigation, we haven't been able to do maintenance, and it's affecting the access of the public. So if we assume that the access of the public is one of the purposes, if not one of the main purposes of creating this forest preserve, what do you do about maintaining the indisputably just foot trails? No, not big enough for snowmobiles or anything like that. They're just the foot trails that there are many miles of throughout the preserve. And can the state remove some saplings and seedlings that may be trip hazards, or, you know, other things of that nature? Or are you saying that none of that is permitted either?
First, I don't believe that issue is technically before this court. It was first raised in a footnote in the state's brief before the Court of Appeals, which is certainly not the time to raise an issue in the first instance. There's no proof of that introduced at trial. Secondly, it's not true that the state has stopped working on trails. They may have cut back, but it's simply not true. And we
Well, but
pointed out
aside from,
But assume for the sake of discussion, yes.
yeah. Well, you don't even have to assume that. All I'm saying is when we're determining what the meaning of these words is, what are we allowing? Do you want us to make an absolute rule here that you cannot remove? You know, and it may take several hundred of these things to, I don't know how many it takes to keep a trail clean and safe, and to keep things from, various erosion things.
We do not believe that the decision from the appellate division or its decision in Balsam Lake would impede normal trail maintenance or hiking trail construction. For instance, in the record, there is tree counts from the construction of trails on Goodman Mountain and Coney Mountain, 13 trees for about a mile, 69 trees for about a mile. And those were trees 1 inch and up. So you can, we believe, within the scope of McDonald, cut a certain number of trees to build a trail.
But are they going to have to come to court every time to determine
if it's a low
whether
number
it's...
like that, if it's lower than the Balsam Lake number, we're not challenging the Balsam Lake number of 350 trees, 1 inch or larger, over 2 miles, 150 per mile. We're not challenging that. We think that allows a reasonable amount of trail construction.
Aren't some of the trails here aren't they removing fewer trees per mile?
One or two of the small trails.
Mhm. So what if they decided that they just wanted to, they would take it one trail at a time, one piece at a time, okay? So we're not talking about either 6,100 trees or 25,000 trees, however you want to count them. We're just going to take this piece, and then we're going to take this piece, and so there you go.
You have to look at that and see if they're in effect, to borrow the term from seeker, which of course this isn't a seeker case, but are they segmenting a broader project to get it under the threshold? Here, we know this is a big system of Class 2 trails. We don't really have to get into that. In the future, Again, if they're just maintaining the trail and they're what they call side cutting or brushing because the branches are growing in from the sides, that's not a problem. None of the, either Balsam Lake or the appellate division in this case prohibit doing that. If a few small seedlings have grown up under 1 inch, shouldn't be a problem.
Chief, may I
to
ask a
remove
question?
those.
Yes, Judge Garcia.
Counsel?
Yes, Your Honor.
I find some guidance perhaps in this language from McDonald to get at the issue I think Judge Wilson and I were asking about, which is, therefore, all things necessary were permitted, such as measures to prevent forest fires, the repairs to roads and proper inspection, comma, or the erection and maintenance of proper facilities for use by the public which did not call for the removal of timber to any material degree. And doesn't that kind of sound like you can take reasonable measures to prevent forest fires, you can do maintenance, or you can erect these facilities for use as long as you don't destroy timber to any material degree?
Yes, Your Honor, that's the sentence I was trying to refer to. And you could, I think, read it either way, frankly. Does the don't cut more than a substantial number of trees apply to the whole sentence or just to the public access projects? The first couple of items in the sentence are intended really to protect the preserve for itself. The others have doing with public access. Again, the material standard comes in at that point. And again, we do not believe that anything that Balsam Lake, or in this case, will prevent the state from providing reasonable access to the forest preserve. They can create hiking trails, they can maintain the trails they have. There's no evidence to the contrary that would dispute that.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honors. So I just want to pick up on a point that was just being discussed, which is this question about context and versus a numbers only approach. And what we can see from McDonald is that this idea of a numbers only approach has already been rejected. It is material degree and substantial extent are relative terms, and it was acknowledged that a constitutional assessment simply can't be made in a vacuum. And that also is borne out by some of the examples that were being discussed earlier. If you have 10 trees that are cut down for some kind of forest fire prevention or maintenance versus 10 trees that would be cut down to be sold off to a company, then we would have two very different situations. So context and purpose do in fact matter. So the test that applies here, the test that was laid out in McDonald, the prohibition on timber cutting is not absolute. It's a contextual prohibition. And this is a fact-based inquiry. This is the kind of fact-based inquiry that courts routinely undertake. So no, there's not going to be, this is not going to cause a change in litigation because McDonald has been on the books for 90 years, and that has been administered. We're asking for a continuation of McDonald.
Counsel,
and the court has
counsel.
yes.
Yes, hi. So let me just, if your focus is on purpose with respect to access, yeah? If we're talking about access, I'm a little unclear. This is somewhat in line with some other questioning you and your adversary have already dealt with. What's the point of the mechanical, as Judge Garcia calls it, the mechanized route? You really want access. Isn't that just about a pedestrian trail, one that might allow for disabled access, of course, in a particular way, but the access that you've provided is for a very limited number of the population. Why isn't that something that we can consider when we're thinking about purpose, if your purpose is access of the public?
So, Your Honor, these are multi-use, multi-season trails. They are not designed to
No, I understand that,
very
but
small
yes, no, I
part of the
understand that.
population.
Counsel, I understand that. That was not my point.
Okay.
The point is that you would not have to build them this way. They would not be constructed this way, but for the accommodation to, again, what Judge Garcia called the mechanized, I think that's the word he used, the machine. It's because you're accommodating the machine. as opposed to access by the general public?
So I want to highlight and I may be repeating myself from before, and I'm sorry, but this idea that these trails are somehow different in nature from other trails on the forest preserve is in fact not only not borne out by the record, but we in fact have affirmed findings of fact amply supported by record evidence going in the other direction regarding the forest canopy, regarding the trails being more akin to hiking trails, regarding the trail construction techniques that were used that minimize the impacts on the environment. So the idea that these trails are in their nature somehow different from the other trails is not accurate. And we're not asking for, yes.
What about the width of the trail?
So
Especially on the curves, Council. Council,
9 feet
especially
in
on the
width.
curves.
Yeah, on the curves especially.
Council, especially on the curves.
On the curves, there are some spots where the trails are 12 feet in width to potentially accommodate snowmobile traffic. That is true. But to focus on that seems to be sort of missing the point, which is that the forest canopy remains intact. That was there's evidence in the record from our expert and plaintiff's expert ultimately agreed and signed an affidavit saying that the forest canopy remains intact throughout.
Can I interrupt you for a second?
Yes.
So I'm a little confused here, okay? So I think the questioning relates to, aren't we just building this to accommodate snowmobiles? My question is, what is the purpose of the snowmobiles? I mean, we know some people like to just go out and ride around in the woods and have fun with them, but does it have anything to do with providing access to people who might not otherwise be able to enjoy the forest preserve in any way?
Yes, Your Honor, it does. The goal of the provision was to protect it for future access by all New Yorkers, and all New Yorkers are not necessarily able to hike along rocky foot trails. So having trails that accommodate differently abled individuals and individuals with different abilities to traverse the forest floor does help fulfill the purpose of protecting the preserve for access by all New Yorkers.
But so would a road, wouldn't it? I mean, if you built a road through there, you could get more people into the forest, but when we build roads, we get constitutional amendments. So the idea that you're going to get people who wouldn't be able to hike in through a road, I don't think is a justification for building bigger trails. I mean, it might be a justification for building it in some way, but it seems to me then you would have to get the same authority you get to build a road, which lets you get people in cars. That opens the park up for many, many more people who wouldn't be able to get to the park. The more roads you build, the more people are going to have access, particularly people who have difficulty getting around, may have physical challenges to get into the park. But that doesn't answer the question of whether or not it's a forever wild problem.
No, that does not answer that question, Your Honor, but this is not a question of balancing access against preservation. What we have here are trails that allow individuals to enjoy the wild forest nature in a way that, quite frankly, is different from looking from the window of one's car on a highway.
But Council, the reality, Council, if I can just, I'm sorry to interrupt you there. Well, I'm trying to interrupt you. But you say sort of access, but the point is access to Forever Wild. It's not,
Yes.
Otherwise you can have access to the park across the street. But that's not what the Constitution is talking about. It's access to the preserve in a particular state. So it's a circular response, it seems to me, to simply say, well, it's access to the preserve, when the point is the preserve being maintained in the way the Constitution requires, given the way you're trying to provide access?
So, okay. Yes, I mean, it is. And there was some discussion before about deference and whether you were asking for deference. No, there was a 13-day trial here where evidence was was put forth and findings were made about whether or not the wild forest nature was being maintained. And the answer to that question was yes. And of course, this court can come to a different legal conclusion, but the point being that there was ample evidence offered that showed that it wasn't simply about increasing access, and that these trails managed to do that, which is one of the constitutional goals of the constitutional provision, while preserving the wild forest nature. So it's not an either or, and of course there would be some point at which you would cross a line, but that is not where we are here. And we know that because we have the context of these trails, which are, situated in the exterior forest land areas throughout the park.
If you cut,
and,
if you cut every seedling and sapling along those trails, would that have crossed the line? Every single one? Since your argument is they're not timber, so they're not protected, in terms of the second sentence.
In terms of the first sentence, and yeah, so if you were to go through and cut every seedling and sapling, then certainly there would be an argument, of course, that would impair the wild forest nature. You are impacting the future of the preserve, and I don't know kind of what the purpose was. I don't know what the project would be that you would be doing that for, but that's very different from what we have here. And it has never been the state's argument at all that seedlings, saplings, anything that's smaller than timber size is somehow unprotected or doesn't get constitutional protection. It does through the first sentence. And if you go back and look at the record evidence from trial, there are many stages at which the consideration of impacts on all forms of vegetation were considered, and decisions were made ahead of time and on the ground as trails were being sited and actually put in place to move this way, move that way, to make decisions on the ground that would minimize impact on all forms of vegetation.
Thank you, counsel. Thank you.
Thank you.